We are saddened that our tragedy has been used by so many that choose to assume, without any fact-checking whatsoever, the worst of jurors, law enforcement, and the prosecutors who bravely and tirelessly have sought justice for Paul and our family.
Oh, Lord. And you know my son is innocent. And then I look at some of these people, how many people they have put to execution. Did they ever think about how many of them was innocent?
The two families demanding justice. This morning, the life of death row inmate Julius Jones in the hands of Governor Kevin Stitt, Oklahoma, and quite frankly, the nation waiting on his decision. Joining me now is Professor Maria Kolar, Assistant Professor of Law at Oklahoma City University School of Law. Good morning to you, Professor.
Good morning.
So lay out Governor Stitt's options here over the next few hours. What can he do?
He can do basically three things. He could grant a stay of the execution by agreeing with the clemency recommendation of the Oklahoma Board of Pardon and Parole. He could announce that he is rejecting the board's recommendation and let the execution proceed. And he could do nothing, which would be, in fact, allowing the execution to proceed. And regarding the first option, if he were to grant clemency, which is the issue that's before him now, he could either agree with the recommendation of the Oklahoma Board of Pardon and Parole that Julius Jones's sentence be commuted or decreased to a sentence of life with the possibility of parole, or he could, on his own, decide to grant clemency in the form of commuting his sentence to a sentence of life without the possibility of parole.
Okay, thank you for laying that out for us. Important to point all that out. I do want to ask here, the drugs used for executions are set for review in February. So is halting the execution until that review is complete, is that potentially another option for the governor, or is it just those three options that you laid out before?
No, that is also an option. And that is an option that there is good precedent for in what Governor Mary Fallin did in 2015 when it became obvious that there were real problems with Oklahoma's execution methods and the way we were doing executions. She stayed executions generally. He could certainly do that. I would just go ahead and say I think that would be the appropriate and prudent thing to do. Even aside from all of the issues in Julius Jones's case, there is ongoing federal litigation in the Western District of Oklahoma, where Judge Stephen Friot has found that there is a serious constitutional question regarding the legality, the constitutionality of Oklahoma's use of the drug midazolam as the first drug in their 3-drug execution protocol. This summer in August, Judge Friot ruled that there was a legal question about that and the issue had to go to trial. It's scheduled to begin in February. In that case, there were 32 death row inmates that were plaintiffs, petitioners. 6 of them declined to name basically an alternative that they would consent to be executed by. John Marion Grant, who was recently executed October 28th, declined to name an alternative, as did Julius Jones. There were 6 of them altogether. In an October 11th order, Judge Friot basically ordered that those 6 death row inmates were kicked out of the case, setting Supreme Court governing precedents that because they had failed to name an alternative, they were not entitled to have remain in the lawsuit. Upon that, the state of Oklahoma decided to go ahead and request execution dates, and they were granted regarding those individuals. Subsequent to that August order, Julius Jones and 4 other of the original 6 attempted to name an alternative, were not allowed to do so. The ruling is basically, you're too late. And that's why we have a small group, a significant group of executions currently scheduled in Oklahoma. 1 has already allowed to proceed. I would point out one other thing, even distinguishing characteristic between John Marion Grant, who was already executed and Julius Jones is my understanding that John Marion Grant was the only death row inmate who never named an alternative, whereas the other ones, including Julius Jones, have basically attempted late, and Judge Frye had ruled too late to name an alternative in order to continue as a part of this ongoing challenge to Oklahoma's execution method.
Great context for what's going on right now. Can you take us inside the governor's head? Because a lot of people are wondering what is taking so long in terms of him making this decision. What could be motivating him to wait until the last minute to do this?
I certainly don't know what is going on in the governor's head or the governor's heart. I would say for everyone, it's everyone, the family of Paul Howell, and all their supporters, the family of Julius Jones and all their supporters, Julius Jones himself. I think it's gut-wrenching and really been a terribly stressful time for everyone, this period of uncertainty. Even the Department of Corrections, which has to prepare for an execution when they don't know what will happen in the end. As to why he's waiting, I don't know. I think this is a terrible idea to proceed. I would say that I'm trying to be hopeful that the fact that the governor has not yet announced that he is rejecting the clemency recommendation of the Board of Pardon and Parole, he has at least left himself the option, even at this very late hour, of granting clemency. And I think there is some hope there, that there is still time to call off this execution, which is scheduled for 4 o'clock today.
Before we let you go, where do you see the future of the death penalty going here in Oklahoma?
There is still broad public support for the death penalty in Oklahoma. I think that's pretty clear from polling and petition drive. I think, though, what has changed in Oklahoma, and I think it has changed, and I would really plead with Governor Stitt to recognize this, is that we as a people, both in Oklahoma as a country, have come to recognize that our ability to accurately assess guilt and deservedness for this ultimate punishment is far from perfect, and I think the population at large has grown much more hesitant about the use of this punishment. You can certainly see that we are in an incredibly low period historically, especially in the modern era, of use of the death penalty. We have become much more hesitant to use it, as we should. I think DNA evidence has taught us that we were, as a people, a lot less accurate than we would have thought we were. DNA evidence is not the answer to every case. There are so many cases which simply can't be helpful. But I think it does teach us a lesson about the need for humility, about the ability of us as human, fallible people, and institutions that are populated by human, fallible people, hopefully doing things for the best of intent. But these cases, and they tend to be terrible cases, are very emotional, and they often result in, too often result in results that are either inaccurate or just too harsh.
All right, Professor Maria Kolar with Oklahoma City University. We appreciate your perspective and your insight this morning. Thank you so much.
Welcome.